2 minutes which to present their case. If you're the appellant, you wish to retain some time for rebuttal, you can reserve up to 5 minutes for rebuttal. And keeping track of the clock will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed when you are.
Thank you, Your Honors. May it please the Court. My name is Tony Sarukas. I represent the plaintiff appellant in this matter, and I reserve 4 minutes for rebuttal.
Thank you.
There's only one issue before this Court. There's assignment of error, and that is that the trial court erred in granting summary judgment and dismissing plaintiff's complaint with prejudice. Facts are really not in dispute. Standard review is not in dispute. It's de novo. It's a question of law here in this case. And although we've briefed a variety of issues, I intend to focus our discussion, or my discussion today, on the first issue and the primary issue, and that is whether plaintiff or appellant's complaint should have been dismissed with prejudice based upon an erroneous order by the Summit County Court of Common Pleas and practice of the clerk of courts in authorizing FedEx service, which was found to be in contravention of the civil rules. Simply put, should a party be prejudiced based upon a mistake by the court or court officials or personnel? And we submit to you that the answer is no, it should not. And I think there's a few things that we can probably agree on that are vital to the underlying, really the underpinning of our argument. And that is, one, the FedEx order, miscellaneous order 325, was authorized by the Summit County Court of Common Pleas back in 2008 and implemented by the clerk of courts. And there was a reason for that. I mean, the backstory, essentially, is, I'm not sure it's relevant to your decision, but just to understand the backstory, is at that time, Daniel Horrigan was having an awful failure rate with certified mail, upwards to 60% failure rate, between 40 and 60%. There was discussions in terms of what could be done to improve service process in this county and statewide for that matter. And I think through the nod of the Supreme Court, through its members, officials, whatever the case may be, a formal or informal pilot program was started here by Daniel Horrigan in connection with the judges here in Summit County to try out FedEx service to see, hey, will it work? And it turned out, 3 years later, it did work because the success rate had gone, I think, upwards to over 90% in terms of serving process on the individuals that it was targeted to reach.
I have a question. You said it was a pilot program. What was the pilot program only instituted by Daniel Horrigan, or was it something that the Supreme Court said, go ahead and do this pilot program? But
I spoke to Daniel Horrigan in the first appeal because we've been dealing with the FedEx issue for a while now. And I spoke to him. The way I understood it was, I don't know if it was a formal, informal program, but the nod was given, look, try this out and see if it'll work. But I can't give you the details beyond that. However, what we do know is because it did work, the Supreme Court ended up amending the rules in 2012 and authorizing commercial carrier service because it works. And it wasn't only that. I was at Bar Association meetings, to be honest with you, of the various associations here, where Daniel Horrigan came to one of them at that time, and it indicated this was going to be a new program initiated by Summit County only to test out the validity and the effectiveness of commercial service through FedEx. And we were all encouraged by that because there's nothing worse than trying to get service by certified mail and either comes back unsigned, you don't even know who it was signed by, there's no name assigned to the green card, and it was really, the post office was doing what it could, but nonetheless, with the resources that FedEx had, it was just doing a better job of effectively managing and getting service on people. And so we were all encouraged to use it. In fact, the docketing statement, when you filed a lawsuit in this case, that the first box be checked off, because it says FedEx, certified mail, regular U.S. mail, sheriff's personal service, whatever the case may be, FedEx was being promoted because they wanted to test it out.
So in this case, did you check both the FedEx box and certified mail, and the clerk of courts decided to send it out FedEx, or did you solely select the FedEx?
No, we solely selected FedEx. It's first on the list, but also because of the effort to want to test it out. We were all encouraged by that. I think it was being promoted. And in fact, if you had a checkbox, I think the policy was to do FedEx at the clerk of court's office if a box wasn't selected or if there wasn't some choice otherwise. So you'd have to specifically request certified mail in order to get it certified mail. Well, we do also know that obviously FedEx was found subsequently by this court that service to be defective. Okay, it was erroneous in contravention of the civil rules, however we want to frame it. Well, we can also agree that the failure in service here was due to the policy of the clerk of courts in issuing, that is, authoring FedEx, and then the Summit County Court of Common Pleas by authorizing FedEx as a standing process server, okay, to have service of process. And we also can agree, I believe, that it's not plaintiff's fault. The appellant was not at fault in terms of the failure of service. So if we isolate why did it fail, it wasn't because we didn't follow the rules. We were following local rules. And plaintiff had a right to rely upon court order and the policy and procedures of the courts.
Was there an amendment to the local rules to allow for FedEx service, or was it just an order of the Summit County?
It was an order by, as far as we know, it's just the order, miscellaneous order 325 is what gave, if you will, FedEx the ability to serve as the formal process server by standing order, but then it was then the clerk courts implemented and allowed them to, if you will, start issuing or sending out complaints, summons by FedEx. So as far as I know, the local rules were not amended. That is the Summit County local rules. So if we're able to agree on those points, and then the plaintiff appellant had a right to reasonably rely upon the fact that service had been in fact perfected based upon the local policies and procedures of the court, the clerk of courts, a combination of both, then a dismissal with prejudice is not fair, and it's just wrong. And, you know, the defense believes, want to tell you, and they start off their argument by saying a bedrock of the American justice system is stare decisis, and they cite Kubiak and the Souter cases, which we were involved in Kubiak. But, you know, stare decisis does not apply to this court on this case based upon those prior decisions, and may be helpful on certain concepts that may address the various issues that we have raised in our brief. But on this precise issue, the court did not address that. So the two distinguishing factors between this case and Souter and Kubiak are the following. One, the court has not addressed the question of, look, if there is a court mistake, should the court or court personnel mistake, should the party sustain that prejudice? That issue has not been addressed. Second, when we look at prejudice, in neither of those cases was the plaintiff appellant, in either of those cases, prejudiced in terms of the outcome of this court's decision, because this court decided in both of those cases that the trial court decision was reversed and then remanded. Kubiak went on to continue on with trial proceedings. Souter was reversed and remanded because the court felt that there was still an issue that was another avenue for the plaintiff to pursue, and that is that their actual statute of limitations had been told because of the underlying plaintiff had suffered a stroke and could have been an unsound mind at the time of the negligence. Therefore, that means the statute never runs against him. And that case was dismissed without prejudice upon remand by this court, by order of this court, that dismissal with prejudice in Souter was wrong, and that the trial court should dismiss it without prejudice, which would give Mr. Souter an opportunity to evaluate that tolling issue and pursue the case again. In this case, dismissal with prejudice, if this court does not reverse and remand, it is over for Mr. Hall. There are no other avenues for Mr. Hall to pursue in order to seek his justice, to have his claims heard by a court of law or by a jury for that matter. But if we're talking about stare decisis, okay, which we believe doesn't apply to this case, but we look at it, we see different cases applying to this court, all right, because stare decisis may be a bedrock of the American justice system, but what is also a bedrock in the American justice system is to look and to obtain substantial justice for the parties, not to allow an injustice to occur. And if we look at the Supreme Court decisions, we've cited a few of them, there's, from 100 years ago, in 1911, we have Cincinnati Tractor versus Ruffin, Robinson versus Commercial Freight, Welfare Finance versus ESTA, all three Supreme Court decisions, which in words or in substance, if I can capture it, indicates either a cause of action or an appeal. Will not be barred due to an act, omission, failure, mistake, or otherwise by the court, clerk of courts, or officer of the court. I mean, essentially, we can summarize what those cases stand for. We also have a couple court appeal decisions that we've also cited, Scott versus Orlando, that dealt with the delayed service of summons, which then prejudiced the party and their case was dismissed, but it was reversed because the clerk of courts didn't do what they were supposed to do, for whatever reason. And then Pollock versus Rashid, which is the first decision, 1996, which I think is probably the closest, you know, if we were going to try to apply it, because it deals with the policy. And in that case, in Pollock, there was an indigent plaintiff seeking to file a lawsuit, or inmate. They had sent the paperwork, the clerk refused to file because there wasn't a filing fee, and the case was dismissed because it wasn't timely filed. The case was filed after the statute of limitations had passed. The Court of Appeals in that case said, because it wasn't even like there was a policy, they stated the fact that because the clerk of courts did not have a policy for informa pauperis filings for indigents, okay, that was error and that was prejudice, and the case should not have been dismissed on that basis because the clerk of courts didn't have a policy in place, let alone one that's mistaken or erroneous. So I think, if we look at these cases, we look at Souter, look at Kubiak, see what the outcomes are on there, which there is no lasting prejudice on those plaintiffs' appellants. And then we look at these other line of cases in terms of Supreme Court or Court of Appeals dealing with mistakes, erroneous decisions. I mean, we can call whatever we want, but ultimately, it was wrong, right? They tried FedEx. It was wrong to have done so under those circumstances. We're not going to re-debate that subject. That's already been done by this court. Ultimately,
You have 4.5 minutes left total.
ultimately, I think when we look at the whole picture in this case, and the issue that hasn't been decided, that we ask this court to confront the issue of should prejudice be committed by a party, what it is because of the actions or inactions or act or omissions of the court or its personnel. Is that fair? And we ask you to say that it's not, to reverse and remand this case for trial. Thank you.
Thank you.
May it please the court. My name is Doug Leek. I'm here on behalf of the defendants, App.No, Dr. Arlan, and Crystal Klein. And on behalf of the defendants, we ask that you affirm the summary judgment that was entered in their favor and based upon the trial court's adoption of the Kubiak versus Ohio Family Practice case and the Souter versus Karamian. The trial court adopted and followed this court's decisions on both those cases and concluded that the plaintiffs did not properly commence this action because Federal Express service of the complaint was not authorized under the civil rules as they existed at the time. And this court should follow the Kubiak and Souter case under the theory of stare decisis, because in those cases, this court was presented with the identical issue of whether or not Federal Express service of a complaint was proper when the amended rules 4.1 to 4.6 did not authorize those. And this court answered that question in a negative, that Federal Express service is not proper to commence a case. However, the analysis here should get to the point of whether or not the case was pending. That's what the Kubiak and the Souter cases address. If plaintiff's case was pending at the time the amended rules became effective on July 1st, 2012, then service could be deemed appropriate. However, the plaintiff's case was not pending on July 1st, 2012, at the time the amended rules became effective to allow Federal Express or commercial carrier service. First of all, the first thing you have to look at is, did the defendants waive the affirmative defense of improper service? In this case, there is no debate whatsoever that the defendants here preserved their affirmative defense and raised it. So there is no waiver of the affirmative defense. So unlike the Kubiak case, where there was a waiver of service, there is no waiver. So for that reason, the plaintiff's case was not pending. Then you have to look to see whether or not two things occurred in this case to make plaintiff's case to be pending. The first one is that the amended rules, if they became effective within the 1 year of filing the complaint, then it could be deemed pending. This case was filed on July 3rd, 2010. I'm sorry, June 3rd, 2010. The plaintiffs had until June 3rd, 2011 to perfect service under the civil rules as they existed. They did not do that. Also, the amended rules did not become effective within that period of time. It became effective almost a year later in 2012. So under this court's analysis in both Kubiak and Souter, the case was not pending. Number one, no waiver of the affirmative defense. And then the service was never appropriate within the 1 year of the filing of the complaint. Now the plaintiffs raised the argument under Civil Rule 86, Roman numeral 2, that there should be retroactive effect of the amended rules. However, this court explicitly rejected that argument. In the Souter case, at paragraph 17, right at the outset of when this argument was raised, this court stated, "We do not agree that the amended rules have retroactive effect." That's paragraph 17 of the Souter decision. So this argument under Civil Rule 86, Roman numeral 2, has already been disposed of in the Souter case at paragraph 17. Next, the plaintiffs argue that they should have been entitled to the saving statute under Revised Code 2305-19 because they claimed they attempted to commence this action through the Federal Express Service. However, this court need not look any further than the Ohio Supreme Court case of Lenev versus Atlas Recycling, which is 2008 Ohio 3921 that we cite in our brief. 2 paragraphs dealt with this issue. Paragraph 17, the Ohio Supreme Court stated in Lenev that in order to have an attempted commencement of a case for the purpose of the saving statute, the service must have been attempted under a proper method. That's the key, under a proper method. And then at paragraph 18, the Ohio Supreme Court went on to say, if there was improper attempt of service, you don't get the benefit of the saving statute under Revised Code 2305-19. And here, we've already established that Federal Express was improper at the time before the amended rules. So they don't get the benefit of the saving statute because it was improper attempt of commencement. And under Lenev, they don't get the benefit of the saving statute.
Did the Supreme Court specify that a proper method of service under the civil rules, or did they just say a proper method of service, which arguably could be service under the miscellaneous order that was approved by the Supreme Court?
I think the Supreme Court was looking at the civil rules and the proper
Did they
procedures.
specifically say service, proper service under the civil rules, or did they just say?
Well, first of all, they never addressed any miscellaneous order because that's kind of unusual here that this was a miscellaneous order and not a local rule. And so, but you have to go back to this court's determination that that service under FedEx was improper. So when you use the definition under Lenev of improper, that applies here. I think an example is some of the old the cases that predated, I think the plaintiffs cited a couple of the cases where the plaintiffs made a demand for service, which was proper, but for some reason the clerk of courts didn't follow that. So that would be deemed proper because they made a demand of service within that 1 year. And so then the plaintiffs did have the benefit of the saving statute because they followed a proper procedure, but the clerk's office made a mistake.
So, under that, now, what he had mentioned was that when they filed the case, the docketing statement, check box, X. If you file nothing, if you don't check any boxes, then we got permit, and it was served by FedEx, we got permit that case to go forward because they didn't select the wrong type of service.
I think that gets to the point of what plaintiffs' counsel was arguing here about the unfairness, and I think this court in Souter addressed these issues knowing these are the identical circumstances as Souter. They're virtually identical, that this court already dealt with straight out FedEx was inappropriate. And then this court in the Souter case at paragraph 24 just specifically addressed this fairness issue when it stated that the Ohio civil rules are not just a technicality, that you can't ignore the civil rules to make up for a rule that was not followed. And so I think this court has already addressed this unfairness issue that goes to this issue of, you know, what they checked and what they did not check. And so at paragraph 24 of the Souter case, I think this court has already addressed that identical issue. And also, I think you can look at the trial courts. This case was not a dismissal with prejudice. This is our second time here. The case was initially dismissed. This court reversed it and remanded it, saying that they had to go outside the pleadings to make this determination. So we went back and we got all the pleadings necessary to establish that we didn't waive the affirmative defense and everything. So this is summary judgment. But what I want to point out is that in the summary judgment order that's at issue here, the trial court adopted its prior dismissal entry and said there's no reason to change it. And in that order, the trial court did state specifically that it was not unmindful and was not unsympathetic to the plaintiff's position. And the trial court addressed that, but said we have to follow the civil rules. And that's because the trial court, when it issued that dismissal entry that was incorporated into this summary judgment entry, was relying upon the Souter case and said that it was bound by the Kubiak and the Souter case to make that determination. I do want to address a couple of the issues of, the plaintiffs not being prejudiced in the other cases, since that's been raised here today. The Kubiak case addressed the FedEx delivery and said it was improper and could not be effective because it was done before the amended rules. But the Kubiak case did find that the case was pending because there was a waiver of an affirmative defense. That's distinguishable. That's why the Kubiak case went back on remand. So that case gave us the ruling prohibiting FedEx delivery and commencement of a case, but found that that case was pending, so the amended rules apply back. That's why Kubiak went back, because of waiver of a defense. The Souter case, this court did say it should have been a dismissal without prejudice. Okay, that case went back, it was dismissed, was never refiled. If it had been refiled, then the defendants could have argued that it didn't have the benefit of the saving statute because the case was never properly attempted to commence. So the Souter case went away. And that's why this case is summary judgment. So it's not a dismissal with prejudice. We went back, we did the summary judgment proceeding, so this court is bound by, we are entitled to judgment as a matter of law based upon stare decisis is a very important theory we have here in application of law. And this court has already resolved this issue in both Kubiak and Souter. If there's any other questions, I'll entertain them, but if not, based upon Kubiak and Souter, we ask that this court affirm the summary judgment in favor of the defendants.
Okay.
Okay, thank you.
Just over 4 minutes.
Thank you, Your Honor.
You're welcome.
Just a couple points. I looked at paragraph 24 of Souter, because I have it here, and it doesn't say anything in that paragraph about prejudice to the plaintiff appellant or court mistake. The court did not address that issue. This is the issue that we're asking the court to address head-on. That is, where there's prejudice and a court mistake, how does that affect the analysis? And we're not walking away because I didn't argue the other points of our brief. And in fact, all the issues that Mr. Leek has raised here in terms of whether it's pending or whether the saving statute applies, those arguments all hinge on the issue that I've been discussing this morning, and that is whether it makes a difference to this court that the failure of service was based upon a court's mistake, not a party's mistake. And just the point of reference, all of the cases cited by the appellees in support of their savings argument, Supreme Court decisions or other court appeals, or their pending argument, do not deal with cases where the court has addressed a court mistake leading to the failure of service. And the point in fact, Lenev, which was a failure of service on personal service because it was not named defendant, later amended the complaint to name the defendant after they found the defendant, and they issued, I think, regular certified mail service, which was wrong under the rules, because the rules say there that it has to be personal service under those circumstances. There was not a court mistake even in Lenev. So those cases all deal with the absence of a court mistake leading to the failure and to what prejudice the party. That is a fact. So it really, this case hinges on whether you believe that it is significant that it's the court's action or inaction, the clerk of court's action or inaction in terms of the failure of service or not. Because if it is, then the reversal should follow. And for those reasons, and because all the prejudice here is sustained by a party that was not at fault, and there is absolutely no prejudice to the appellees, we ask for the reversal. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides and posted to our website and that is Supreme Court.